Mr. Arghya Sengupta, thank you so much for speaking to us on Times Now on Turning the Page. It's a pleasure to be speaking to you. And you've come out with this wonderful little book, Hamin Ast, a biography of Article 370 that you've co-authored with Jinali Dani, Kevin James, as well as Pranay Modi. And this is actually a very interesting way to deconstruct what is a fairly complicated subject. It's about 90 odd pages. And you've begun this series with Article 370, but I presume you'll also be touching other very contentious as well as complicated subjects. They're at least complicated on the surface, but can be deconstructed in the manner that you've done here. So is this a project that you plan across topics, or is this a standalone?
Thank you very much, Siddharth. Thank you for having me on Turning the Page. It's a real pleasure to be here. So first up, Hamin Ast is the first of a larger project. And this project is called Navi Books. The idea is that can we take, as you yourself said, complex, contentious issues of constitutional law, other areas of law and governance, and write it in a way that is accessible to the general reader outside the legal fraternity. And that is the idea of Navi Books. It's actually a digital-only publication. So for folks who are watching, it looks very nice as on your mobile phone or your iPads or more other devices. Siddhartha was kind enough to hold up a hard copy version of it. But I encourage everyone to log on to navibooks.in and see it on their mobile phone. So the next book that's coming out from Navi Books is on the Office of the Governor, which should be out later this year. Again, a very complex, contentious issue. And so we hope to do this over the course of a number of years. And Article 370 is our first one.
So coming and diving straight into Article 370, what stands out about this biography of Article 370, its history as well as its evolution, is that the authors, including you, do not shy away from taking a legal position on it, especially with regards to the constitutionality of the decisions that were taken on the 5th of August 2019 by the current dispensation. And just to summarize to our viewers, you actually take a position that this might struggle to stand the test of judicial scrutiny purely from a legal perspective. So let's dive straight into the brass tacks, Mr. Sengupta. Why do you believe that the decision taken on the 5th of August 2019 actually violates not just the spirit, but also the letter of Article 370 as it was originally conceived and as it evolved?
Let me first start by saying, Siddharth, that the issue of Article 370, both its constitutionality as well as its continued existence, is an extremely complex issue. So it is not an open and shut case. Okay, so let me make that very clear right at the outset. Now, obviously, the reason as to why it's complex is because of the fact that Article 370 was always meant to be a temporary provision, right? So it's very clear from the article itself that it is a temporary provision which is meant to be a placeholder till the time that the representatives of Jammu and Kashmir and the representatives of the Union of India can come together and make a substantive agreement on what this relationship is going to be. And actually, they had gone some way into doing that in 1952 with the Delhi Agreement between Sheikh Abdullah and Jawaharlal Nehru, which we have detailed in our book. But then it broke down for a number of reasons, and I'm happy to get into that. And so the Sheikh was deposed and then incarcerated, and you had Bakshi come in, and then Article 370 became a permanent feature. Then Article 335A and the presidential orders kept happening under Article 370. So that kind of led to a temporary feature suddenly becoming permanent. Okay, so I think that's the historical context in which it is located. So as far as the National Democratic Alliance and the Bharatiya Janata Party and its predecessor, the Jan Sangh, is concerned, they have been consistent in their view that abrogation of Article 370 is a consistent part of their election manifesto. So now how do you go about doing it? How do you go about doing this? Now, there is, as far as Jammu and Kashmir is concerned, Article 370 has two clear requirements. One, if you want to abrogate, nullify, or amend Article 370, you need to take into account the views of the Constituent Assembly of Jammu and Kashmir. So they will have to make a recommendation. Now, the Constituent Assembly doesn't exist. So what do you do? So logically speaking, without getting too technical, you'd say that the Legislative Assembly of Jammu and Kashmir is the successor body, right, to the Constituent Assembly. There might be some issues with that argument, but let's keep paper over that for a moment. Now, there is no Legislative Assembly because there is President's rule at that point of time. So that means it's the who is exercising this power? The Parliament is now exercising this power. So now you see the entire construct of Article 370, which is it takes two hands to clap. The hand of Jammu and Kashmir and the hand of the Union of India must clap together. But now it's like the Union of India is clapping its own hand, right? So while I understand the need for maybe the need for president's rule, I understand the need that it's a security concern, all that is clear. But purely in terms of the constitution, there is an understanding of Article 370 that it takes two hands to clap, and here two hands haven't clapped. Number one. Number two is that since you are a fan of the basic structure and you're interested in the basic structure, one of the features of the basic structure doctrine is federalism, right? And while Jammu and Kashmir is a unique case, I'm fully cognizant of that. But the fact is that president's rule can be imposed in any state, right? And it is at the end of the day a constitution that we are talking about. If the president's rule can be imposed in any state, then can a state be legislated out of existence during president's rule? I mean, the answer will surely be no, right? It's surely no. As in, I can't really imagine that, say, the state of Tamil Nadu or the state of Odisha or any other state for that matter is legislated out of existence. Okay, it's not likely to happen. But we have to be clear when we are interpreting the constitution that it is much more than Jammu and Kashmir that is at stake. So it is a case that could go either way. There are some. It's a very clever way in which this constitutional amendment was done. But I think we need to take into account the larger picture, both in terms of the history that I outlined, as well as the future in terms of the precedent that it sets.
And since you basically talk about the need for two hands to clap, you're actually referring, and as you chronicle in your history of Article 370, to the letter that was originally written by Lord Mountbatten to Maharaj Hari Singh of Jammu and Kashmir, who was then the reigning ruler, on the 27th of August, 27th of October, 1947, a day after the instrument of accession was actually signed, where Mountbatten clearly says that on larger substantive issues of integration, and not necessarily only the three issues outlined in the instrument of accession, the will of the people of Jammu and Kashmir will have to be taken on board. So that is basically the genesis as to why Jammu and Kashmir is a unique case as opposed to a lot of the other states that were also princely states that were integrated into the Indian Union. So if you could just give our viewers a perspective on that too.
Yes, I think this is, you've hit the nail on the head, Siddharth. Jammu and Kashmir was a princely state even on the 15th of August 1947 when India became independent. By that time, most of the other 554 princely states had become integrated. We knew that there were outliers. Junagadh, Hyderabad, and Kashmir were the outliers. Now, till October 1947, Jammu and Kashmir remained this way. Maharaja Hari Singh had a grand vision that it would be the Switzerland of the East, kind of remain neutral. But at that point of time, there was armed militia from Pakistan on the Pakistani side of the border who attacked the state. Now, there was no way in which Maharaja Hari Singh could defend the state and needed Indian help. There was no way that the Indian army would come in unless it was its own territory, because the Indian army did not want to go into foreign territory. So an instrument of accession was signed. If the instrument of accession was signed, this was the same document as every other of the 554 Maharajas had signed. Nothing special, nothing unique, just saying that Jammu and Kashmir would now become a part of India, except for foreign affairs, defense and communication. All other matters would continue to vest in the Maharaja of Jammu and Kashmir. Now, in response to that, when the government of India accepts that accession, Mountbatten is still Governor General in India, though it is independent India. Mountbatten, on his own, representing the Union of India, writes that yes, while I accept it, the ultimate determination of the future of Jammu and Kashmir will be in accordance with the will of the people. Now, this is something that was not needed. In fact, Sardar Patel was not very keen that this be written at that point of time. But Mountbatten decided to go ahead and write it as the Governor General. Now, once you write it, it's the sovereign commitment made by the Union of India that it will respect the will of the people. And Jawaharlal Nehru goes and on All India Radio and again reaffirms the fact much later that the will of the people will be ascertained. And this is the genesis of the idea that there will have to be a plebiscite or a referendum in Jammu and Kashmir in order to determine its future. This is something that obviously could not happen because Jammu and Kashmir remained divided, because as you know, the line of control was drawn. There was a ceasefire that was brokered by the United Nations at the end of the year on the 31st of December. From the 1st of January, the line of control was drawn, and wherever the forces were on each side, that became the de facto line. So with part of the state of Jammu and Kashmir being so-called occupied by other parties, as there was no way in which this plebiscite was going to happen. But the fact that it doesn't mean in law that it should not happen. Because at the end of the day, it was said that the will of the people would be ascertained. Article 370 tried to reflect that by saying that the will of the people would be ascertained by the Constituent Assembly of Jammu and Kashmir and then later by the Legislative Assembly of Jammu and Kashmir. So this is the place where this genesis of this idea of the will of the people, of the Constituent Assembly, and of this getting two hands to clap really came about. And that's why I think that when we see this as a legal issue, it points us in one direction. When you see this as a political issue, you tend to start seeing the inequities of this, right? As in it was a unilateral declaration that was made at that time, as if parties were largely divided. They were not on the same page on this issue. Everyone thought we would make a substantive disagreement, which is why Article 370, while it is certainly a legal issue in a rule of law country, Article 370 has to be seen in this wider context to understand the genesis of its politics.
One of the very interesting facets to the short biography is the fact that you also recall discussions that took place in Parliament, especially in the year 1964, when a move was made on the part of one of the members of Parliament to actually abrogate Article 370. This was brought to the floor of the House. And there were several people in Jammu and Kashmir who were representatives of J&K in Parliament. I believe it was 68. Correct me if I'm wrong. I think it was 1968 and not 64. And there were several Muslim representatives of Jammu and Kashmir in Parliament who at that time believed that Article 370 should go because they believed that the article was actually holding them back. But the then Prime Minister of India, Indira Gandhi, spoke on the floor of the House, and she did say that this should continue, and that status quo pretty much about Article 370 should be retained because 370 by then had already started to be used as a vehicle for greater integration and basically getting more central laws to apply to Jammu and Kashmir, something that had already begun at the time that GM Sadiq, as well as his predecessor, Mr. Bakshi Muhammad, were in charge in Jammu and Kashmir. Do you believe that this represented a missed opportunity where there seemed to be political consensus, at least in favor, heading towards abrogation or pretty much integrating completely Jammu and Kashmir with the Union of India, that this step ought to have been taken and not prolonged as far ahead as 2019?
See, as with everything with Jammu and Kashmir, there is no straight, easy answer to your question. It is a complicated issue. My personal view is that the missed opportunity was actually in the mid-1950s, where in 1954, when there was a presidential order that was passed. That presidential order was basically, for your viewers, like a mini constitution. It was basically saying what part of fundamental rights chapter would apply to Jammu and Kashmir, what would not apply. Other Article 35A, which is what we know of, which is the special protections for permanent residents of the state and so on, all came in through that presidential order. I think at that point of time, there was a missed opportunity that they needed political statesmanship on both sides, in Delhi as well as in Srinagar, to come together and say that we are now going to do away with Article 370 and we will agree on a compact within the confines of the Constitution of India that recognizes the special status of Jammu and Kashmir, but at the same time makes it one with the rest of the country. Because it's not the case, and it is a misnomer to think that Jammu and Kashmir is the only state in India that has special status. Of course, the northeastern states have special status, but more importantly, there are states like Maharashtra where there is special status for some parts of Vidarbha for certain issues. There's certain special status for Hyderabad because they earlier had the Mulki rules that applied. So it is not to think that the Indian federalism is about one symmetric federalism. There is asymmetry, and Jammu and Kashmir needed to be a part of that asymmetry, but within the contours of the Constitution of India. So first, I think the missed opportunity was in 1954, where Article 370 de facto became permanent. Now, as far as the 1960s are concerned, I think this is something that is, there are two answers to this. One is that there is a strong view and with some degree of justification that from Bakshi's government onwards, and you basically had puppet governments in Jammu and Kashmir, right? So they would dance to the tune of whatever's being said from Delhi. Okay, so that's one part of the story. The other part is the fact that there is some justification to what was being said, because Article 370, in some sense, by that time had become a symbol. If I were to recollect something that we had also adverted to in our book, Gulzari Lal Nanda, who was the Home Minister, said at that time that Article 370 is not a wall, because some people had said in Parliament that it is a wall which separates Kashmir from the rest of India.
It's a tunnel.
But exactly. It's a tunnel. It's a tunnel through which a lot of traffic has passed and more will pass. So the idea is that Article 370 had ceased to be relevant except for being a symbol. Because as we've said in our book that there are 97 subjects in the union list, 91 or 92 of them, I forget the exact number, applied to Jammu and Kashmir anyway. Large parts of the constitution applied to Jammu and Kashmir anyway. So the fact of the matter is that it had become a symbol. So it was really not of much use at that point of time. So I think that they were all missed opportunities. And so there was no need to prolong it in this sense. But having said that, as a lawyer, I must say that if you are to do away with it, you have to do away with it in the way in which it is provided for. And that might be a little bit difficult. It might require consensus. But as Wajahat Habibullah, who was a serving officer in Jammu and Kashmir, who's written an excellent account of his time there, has said, and he said that, and he said this in our book launch as well, he said that perhaps if there was an outreach done at the right time, as in with citizens of Jammu and Kashmir, maybe people would have agreed that we can get rid of Article 370 and make sure that the economic benefits of being part of Union of India flow to Jammu and Kashmir. So I think that this is the context in which I would like to place this discussion.
Let me, in fact, go back to something that you said earlier in the interview, and this comes back to the legality aspect of things, that the successor necessarily to the Constituent Assembly, which was dissolved in the year 1957 in Jammu and Kashmir, is not necessarily the Legislative Assembly of Jammu and Kashmir. This is a point that you make, especially when you discuss the constitutionality of the decisions that was taken on the 5th of August 2019. So therefore, for the union government to simply substitute the words Constituent Assembly with the Legislative Assembly and then have the powers of the Legislative Assembly pretty much passed to Parliament because we were in a state of President's rule in Jammu and Kashmir might not necessarily stand the test of legality, because there is a difference between a Constituent Assembly, which is something that is to be constituted, and an already constituted Legislative Assembly and the powers that each of them actually has. So if you could explain our viewers that distinction, because this is something that is likely to be raised by those who are critical of the decisions of the government on the 5th of August 2019 purely from a legal perspective.
Absolutely. So let's take a couple of steps back. So one, in political theory, there is the constituent power. The constituent power is the power to enact a constitution, right? So this happens maybe once in a lifetime. People come together and enact a constitution for themselves. Now, then there is the constituted power, which is that under the constitution, there is parliament, there is government, there is judiciary. All of these derive their power from the constitution itself. Okay, so the powers that are exercised by parliament in its lawmaking capacity or the state legislature in its lawmaking capacity is a constituted power. Okay, so the difference, as the petitioners have also argued in the case, is the fact that when Article 370. Article 370 actually makes reference to the Legislative Assembly of Jammu and Kashmir, the government of Jammu and Kashmir, as well as the Constituent Assembly of Jammu and Kashmir for different matters. Now, in relation to Article 370 itself, that is, how can Article 370 itself be abrogated? It says that you need the recommendation of the constituent body, okay, which is because it's the people in that sense which have to decide. And this is the closest that you can get to the people without actually going to a referendum, which as I explained earlier, was not possible. So given the fact that it mentioned the Constituent Assembly, there is an argument to be made that the legislative intent was that this had to be done by the Constituent Assembly, certainly not the Legislative Assembly, and certainly not the Parliament of India, which was acting as the Legislative Assembly at that time because it was President's rule. Now, this is the argument. But let me put the counter as well, because I think it's important to be fair in this matter. Now, if Article 370 has to go, the fact is that if you were the government, there is no constituent assembly, right? So if you were to take this very strictly by the letter, maybe this is, it will lead you to an absurd argument that you have to set up a new constituent assembly, right? Now you can't set up constituent assemblies wantonly for a purpose. So the logical extension of this is the fact that it's the people. Now the Constituent Assembly has done its work. It's gone. It decided not to make a recommendation. It can be seen to have waived this power that it had to make this recommendation. So I would say that logically, if this power was exercised today by legislators of Jammu and Kashmir, I think this act would have been legal. At the end of the day, it's the representatives of the people of Jammu and Kashmir who are doing it. Now, puppet, these are all very different points. Okay, these are not legal points. So I would say that till that stage, it would have been all right. But there is a certain fundamental problem when that power also is now exercised by the Union of India, which is the other party in this case. It's not like if it's a non-interested party, it is the other party in this case. So I think that this is the distinction that we need to understand, that what can and what can you not do during President's rule. And I think this is a question whose relevance goes far beyond Jammu and Kashmir in India's constitutional history and future.
Yeah, because you also argue that this might set a dangerous precedent of sorts in some other cases too, especially when the luxury, so to speak, of President's rule can be used to rummage through legislations or articles that might not necessarily be in the best interest of the state. And that this might in fact end up posing a threat to the federal structure. But let me in fact come to something that Mr. Harish Salve has said in his defense of the government's decision and the legality of its decisions. And he gave an interview to The Wire, which I'm sure you would have also heard in 2019. And he said that the views of an assembly are passed by a resolution, and a resolution is one of the powers of an assembly. And under President's rule, the powers of an assembly are transferred to Parliament. That includes the power to pass a resolution as well. It's the power to pass a resolution which lies at the heart of the government's mechanism for changing the status as well as the size of Jammu and Kashmir. And that power has been transferred to Parliament. And therefore, there's nothing unconstitutional about the way the actions of August 5th, 2019 were actually undertaken. What would be your response to that specific counter coming in from Mr.
Yeah, so see, he's technically correct. He's technically correct in what he's saying, because the fact is that all the Legislative Assembly's powers, including the power to pass a resolution, now vest in Parliament. But why does it vest in Parliament? We have to go back to why does President's rule exist? President's rule exists because there has been let's keep it simple, a breakdown of constitutional machinery in the state. Okay, so now the state cannot be governed from its state capital, so it has to be governed from Delhi. This is why President's rule exists. So all the powers that are there in the state government, all of those powers are now there in Delhi. So to that extent, Mr. Salve is absolutely right, as in there can be no cavil with this argument. But the question now that arises is that is the power to recommend the dissolution of a state itself into a union territory, is that a power that can be equated to appointing a tehsildar? Okay, are we going to make that argument? Is it a power that can be equated with saying advertising some posts for government? It's really not on the same plane. And there are two reasons why it's not on the same plane. First is that it is a power that is specifically vested in the constitution, in not just the legislature, but in the constituent assembly. So it is not an original power of the legislature or the government. It is an original power of the constituent assembly. Number one. Number two, and I think this is even more critical, is that this power has to be exercised in a particular context. Because if we see Article 370, ultimately, and I actually want to read the article, that part of the article, because I think this will be useful for your viewers, so that I can make the point clearly. Says that as far as this 370 subclause 3 is concerned, the president may, by public notification, declare that this article shall cease to be operative. I'm leaving out the rest, provided that the recommendation of the Constituent Assembly of the state shall be necessary before the president issues a notification. So who issues the notification? The president. Okay. Who does the president have to consult? The Constituent Assembly. Now, the Constituent Assembly now is who? The Constituent Assembly now, under president's rule, is the president. Let's be clear. It's not the parliament. It's the president. Okay. So the president has to consult himself, wearing two different hats while he's exercising this power. Okay. Now, so there is a fundamental inequity to this. As as a lawyer, you feel that there is something fundamentally wrong in something when it happens in this way. So while technically Mr. Salve may be absolutely correct that the powers of the state are now in the center, he's absolutely correct in that. But the fact is, this is not just another power. And this is something the Supreme Court will have to decide, keeping in view certainly Jammu and Kashmir and its unique status, because that's something that must always be kept in view, but also the future of Indian federalism. So my sense, I'm a pragmatist, the fact is that it can go both ways, okay, because this question is not an open and shut case, as I've said very clearly. There are arguments for its constitutionality, which we've made in our book. There are arguments for its unconstitutionality, which we have certainly made in our book. And I think the Supreme Court will have to decide. It's a tough case, and I hope they hear it soon.
And last couple of questions, Mr. Sengupta. One is, of course, about the inconsistency. Now, you talked about the 1954 presidential order, which paved the way for the creation of Article 35, which many believe was inherently discriminatory for a whole lot of reasons, because it drew a distinction between permanent residents as well as some of the others who live in the state. And people have, of course, talked about the lack of domicile certificates to the members of the Valmiki community, among a whole host of other people who'd been living in Jammu and Kashmir for generations, but had been denied their rights in multiple ways. So the decisions of the 5th of August address that. And that's one thing that many have actually said is something that ought to have been done much earlier, and therefore it's the right decision. But then that also points towards an inconsistency that you brought about in your conversation with me, which is that the special status and such similar rights also exist in other states. You can talk about Article 371, etc. So this would also therefore have to be addressed, because that will be brought before the Supreme Court, presumably, that if states like Nagaland as well as others can have a certain set of special rights, and draw that same distinction that has been attempted to be drawn in Jammu and Kashmir between bona fide permanent residents as well as others. This discrepancy, therefore, between states need to be addressed at a wholesale level. And you can't just do a piecemeal approach wherein you abrogate this for Article 370 but not do it elsewhere in India. Because you do also have the issue of inner line permits, among a whole host of other things that kind of draw distinctions between people in different parts of the country and in those states.
Yeah, so Siddharth, actually, this is a very good question, because let's remember one thing. This special status is being provided in the Constitution itself, right? So the fact is that it's not as if we can easily say that this special status is unconstitutional. It violates Article 14, because it's there in the Constitution itself. So one is that ordinarily that should have been good enough. But the fact is that we then have to assess as to, is this special status, not just for Jammu and Kashmir, but for other states as well, does it fall foul of the basic structure doctrine in terms of the fact that we are a federal state, right? Because that's potentially the only thing that we could think about. Now, given the fact that we are a federal state, what kind of federal state are we? The fact is that we know that we are not a homogeneous federalism. We are not a federalism that has the same rules for all states. And this is not even getting into questions really of special status. The fact is that there are differences that exist both culturally in the country, as well as in terms of various aspects of governance in different states. So I think it is a well accepted canon that India is an asymmetric federalism. The degree of asymmetry in different states may be different, number one. So I think there cannot be a case that the idea of special status or special provisions like permanent resident notifications, which exist in a whole host of states actually, itself is unconstitutional, number one. Okay. Number two, as far as Article 35A is concerned, because there is an argument that Article 35A is not exactly in the Constitution, it is pursuant to a presidential order. So it's kind of an indirectly in the Constitution, unlike the case of Nagaland and so on, which are in the Constitution itself. Now, if 35A had to be done away with, then 35A could have been done away with by removing the presidential order. See, the fact is that you don't need a sledgehammer to swat a fly, and 35A is not a fly. 35A is very important. In fact, in some sense, 35A is one of the key drivers of this political resentment that exists against Jammu and Kashmir. But then 35A could have been done away with. There was a case in the Supreme Court about 35A anyway. As in, that could have been heard, or the presidential order itself could have been nullified. So my point is that as in the problem here, that's why we can't, and I keep coming back to this, and all my co-authors also, we looked at this, that we can't see this solely as a technical legal issue. As it's necessary to see it in its larger political context. And I think special status for Jammu and Kashmir itself is not unconstitutional. If we were to take that claim, then a lot of things would be unconstitutional in relation to a lot of other states, which would lead to real instability in this country. So I think no one should argue that special status is unconstitutional. As far as 35A is concerned, we could have narrowly tailored something if something had to be done, but that was not done.
You end the biography by saying the last word in the biography of Article 370 may yet be written by the Supreme Court of India. It's been more than 3 years now. Why has it taken as long as it has? Because this is an issue that concerns the basic structure. So why is the Supreme Court taking as long as it has to deliberate on this?
So I think now I'm very hopeful with Chief Justice Lalit having come in. Constitution bench hearings, as you know, are happening quickly. There are already the EWS reservation case is being heard, and Constitution bench matters are listed one after the other. The Article 370 matter is not listed though in the first 25, but given the fact that they have started listing Constitution bench matters, I'm hopeful that it will happen quickly. Why it has not been listed, I will not be able to answer that question. That's because the Chief Justice of India is the master of the roster and decides to list cases in whatever way they think it can be taken up with the capacity of the court that he or she has. So at this point in time, I can't answer that question of why it has been taken up, but I can certainly say that whether late or otherwise, as in it will be taken up. And once it is taken up, as in I hope that we go into it in detail. There are many arguments to be made on both sides on this. And I'm pretty hopeful that in the next year or two, this matter is taken up. Whether the Supreme Court will be able to turn the clock back or not, I'm not sure of what's going to happen there. But certainly I hope that in a country which swears by the rule of law, the constitutionality of this issue is determined authoritatively by the Supreme Court of India, irrespective of what result it reaches.
And like you rightly articulated, this is an extremely complicated subject, and irrespective of which part of the divide you are on, even the legality of the decisions on the 5th of August 2019, one would want to see the deliberations happen in court fairly soon. It's a matter of fundamental importance as far as the basic structure is concerned, and therefore both the arguments for and against, however compelling they might be, need to be brought forth in a court of law fairly soon, and one hopes the Supreme Court takes this up actively and very soon as well, like you've said. So thank you so much, Mr. Sengupta, for speaking to us. It was a wonderful conversation. We could not cover every aspect of what you've delved in this particular biography, but I hope this interview is a sufficient primer for people to actually explore this far more in depth by reading this book. So thank you so much for your discussion and your time.
Thank you, Siddharth. Thank you for having me. And I hope your viewers read the book. It's a short 100-page book. And I think there's a lot there about the history of Jammu and Kashmir and of India in that book. So thank you very much for having me.